Correcting common Medicaid misconceptions. Medicaid planning is an extremely complex area of law, and it's no surprise there are so many misunderstandings about how rules are applied. Because of the high risk associated with asset planning, you should seek the advice of experienced elder law and Medicaid planning attorney before acting. Misconception: I should transfer assets before applying for Medicaid. For many people, the first impulse is to transfer assets before applying for Medicaid based on the incorrect belief that it's better to have fewer assets when they apply. But by following this route, they may wind up spending down more than is necessary. When a couple applies to a state for Medicaid to support the needs of one spouse, the couple is allowed to protect a portion of their assets, limited by minimum and maximum amounts, for use by the healthy spouse. When one spouse enters a nursing home, Medicaid takes a snapshot of the couple's assets. This assessment fixes the maximum share of a couple's assets that can be protected and how much must be spent down before an individual can qualify for Medicaid benefits. The minimum and maximum amount of assets the healthy spouse may keep is called the Community Spouse Resource Allowance. The Centers for Medicare and Medicaid Services sets the CSRA annually. In 2024, the minimum amount is $30,828 and the maximum is $154,140. Not knowing how your state's Medicaid eligibility works can hurt you. If you transfer assets before applying, your snapshot could reflect a reduced level of assets. After you apply, you may learn that you can retain only half of what you have left. It can be less than half of the amount you owed before you began an asset transfer. For example, John and Jane have $215,000 in Medicaid countable assets. Before applying for Medicaid, the couple spends down $55,000 on expenses that are not penalized for Medicaid. Therefore, when John applies for Medicaid, he and Jane have $160,000. To qualify for Medicaid, the couple may be required to spend down 50% of what they owe, i.e. 50% of $160,000, which leaves Jane, the healthy spouse, with $80,000. If John and Jane had applied for Medicaid before spending down their assets, they could have kept half of the original $215,000, leaving Jane $107,500. Misconception: property held jointly wherein a spouse's name is protected from Medicaid. The facts: when determining the Community Spouse Resource Allowance for a healthy spouse, all of a couple's assets, individual and joint, are pooled. The spouse deeming rules consider all individual owned assets as belonging to both, even if a prenuptial agreement exists. Also, assets jointly held with the child can be considered available to pay for nursing home care unless the child establishes that assets inaccessible or didn't originally belong to the parent. Misconception: assets transferred to a trust are protected from Medicaid. The facts: perhaps. The use of trusts require careful planning and a careful review of your financial needs and goals. You cannot transfer assets into a trust, retain control of those assets, and qualify for Medicaid. If you transfer assets to an irrevocable trust, you must give up complete control of your assets. Assets transferred to a trust within 60 months before applying for Medicaid might be penalized and result in a period of ineligibility for Medicaid long-term care benefits. From a practical perspective, it's important to ask yourself a few planning questions before transferring property to a trust in anticipation of qualifying for government benefits. Are you willing to surrender complete control? Where will you obtain emergency funds? Are you willing to accept state aid rather than assume some of the benefits of privately paying for care, such as the flexibility to choose a facility? Misconception: making gifts to my children is simpler and less expensive than creating a trust. People make gifts to their children for many reasons, including protecting a parent's assets from being drained by health and long-term care costs or providing children with funds to support the parent. The facts: according to Medicaid, any gift that a parent made to a child within 60 months of applying for Medicaid assistance is available to help pay for parents' care, regardless of intentions. Misconception: entering the nursing home as a private pay patient requires me to use all of my and my spouse's assets before I can qualify for Medicaid. The facts: many people erroneously believe that they have to be impoverished before the state will help. Although Medicaid is for the needy, regulations like the Community Spouse Resource Allowance are in place to protect assets for the healthy spouse. So you are not required to exhaust all of the assets to pay out of pocket for nursing home care. Care facilities may pressure you to pay out of pocket, and they are paid less by the state. You should seek advice from an experienced elder law attorney before spending down a significant portion of your assets on the private pay rate, particularly if your resources are limited. Thank you for your time. Stay tuned for part 2.